बिस्मिल्लाहिर्रहमानिर्रहीम। मैं सौलत मिर्ज़ा आज कौम के सामने, लोगों के सामने, दुनिया के सामने हूँ एक इबरत की तरह।
This Real Talk report will examine the legal merit and ramifications of Saulat Mirza's confessional statements, which were made in a video that has been leaked to Pakistani news media. In the said video, Mr. Saulat Mirza has made several passing allegations on some key leaders of MQM, but only after admitting his own guilt. Whenever a person is arrested for any criminal offense, from the time a first information report by the police is registered, which is commonly known as FIR in Pakistan, until the time that person is convicted or acquitted, this entire legal procedure is bound by the laws of the Criminal Procedure Code, which are under the Constitution of Pakistan. This code, which is generally known as CRPC, defines each and every step of the trial. Doing so provides the legitimacy that any trial requires to be rendered fair and just in the eyes of the law and the world. Mr. Saulat Mirza was accused and since have been convicted of the murder of Mr. Shahid Hamid, the then chief of Karachi Electric Supply Corporation, alongside with his driver and one guard. The murder took place in 1997. Saulat Mirza was arrested in 1998 and convicted in 1999. Saulat Mirza was also at one time an activist of MQM, but was removed from his duties and party due to the same allegations and proceedings before his trial. MQM is and never was a party in this case. At this stage, however, the leaked video incriminates the entire political party and its elected leadership. The court case of Saulat Mirza has been completed to the maximum level of completion. During such proceedings, the Criminal Procedure Code, or the CRPC, offers 3 clear opportunities to an accused to admit his guilt and make a comprehensive statement on his own behalf. The accused in this case would be Mr. Saulat Mirza. The first opportunity is during investigation. As defined in the section 164 of CRPC, an accused can admit his guilt in front of police or a magistrate at any time before the commencement of trial. Mr. Saulat Mirza never admitted guilt, nor did he ever allege anyone else to be a perpetrator or a partner in this murder. He maintained his innocence. The period of this opportunity was 1998 after his arrest in Karachi. The second opportunity is before the trial begins. Before the prosecution begins to present its case based on the charge sheet made as a result of the investigation, the court offers the second opportunity to the accused to admit his guilt or allege someone else to be the perpetrator or partner in this crime. This stage is defined in section 242 of CRPC, titled Charge to be Framed. Saulat Mirza again maintained his innocence and did not incriminate anyone else. The period of this opportunity was when the case was presented in front of an anti-terrorism court in 1999. The third opportunity is right before the end of trial. When the prosecution has already presented all its arguments and evidences, the section 342 of the CRPC offers the third opportunity to the accused to admit to guilt or make any comprehensive statement on his own behalf. Mr. Saulat Mirza again, in his recorded statement of the accused, maintained his innocence and called himself a victim of circumstances. Mr. Saulat Mirza was convicted in triple murder and sentenced to death in the May of 1999. This whole procedure defines the commencement of trial. These are 3 very clear junctions where Mr. Saulat Mirza could have admitted to his own guilt and possibly incriminate others for his statements to have any worth or merit. He could have chosen to testify against MQM or any number of individuals within MQM in order to receive any level of mercy. He did not do that. The case was concluded with a conviction and a death sentence. The case then went on to satisfy one appeal in High Court, then one in the Supreme Court. There were 2 reviews, another petition for a review in High Court, and finally a 3rd review in the Supreme Court. Never in any of these stages did Mr. Saulat Mirza include the admission of guilt and incrimination of others. Every appeal was rejected and every review upheld the same conviction. 17 years later, and as far as the Constitution of Pakistan is concerned, all due diligence has been satisfied. The highest courts of the country have reviewed and rejected any change in the verdict more than once. What is the legal value of this confessional statement in a video?
Bismillahirrahmanirrahim. मैं Saulat Mirza.
Is this a statement of a man right before his death when he has no motivations to lie? Saulat Mirza has made same claims with the same narrative incriminating people of relevance in MQM 17 years ago. This is not the first time.
तो वहाँ पे बाबर गौरी ने अल्ताफ हुसैन से बात करवाई थी। अल्ताफ हुसैन साहब ने मतलब बाबर गौरी हिदायत दी थी कि किसी के एमडी को मारना है।
Yes, there was another video back in 1999 during his trial with the same story but different names. But in court he never admitted guilt, and prosecution against him never submitted those statements in the trial as evidence. If they weren't admissible as evidence then during trial, how are they going to matter now? Mind you that the entire trial of Saulat Mirza is now part of judicial record of Pakistan. Anyone can read it. Can anyone be legally incriminated, arrested, and put on trial based on these statements? No. According to Section 403 of CRPC, no one can be tried twice for the same crime. Therefore, a new FIR will be illegal. Plus, Section 164 already renders this statement illegal because it has been collected after the commencement of trial. So, no legal value whatsoever. If there are new information about crimes or criminals, shouldn't that be investigated in the light of this new statement? Mr. Saulat Mirza have been in jail for last 17 years. He has been tried and convicted through a proper trial which has been upheld and validated several times over by the highest institutes of the country. Similar statements by him 17 years ago were not submitted as evidence during his trial by the prosecution back then. What new information has he gathered since then while being in jail all this time that is worth overturning his entire trial, bypassing all the institutions who have validated the trial? The larger question, however, is that who is asking him these questions, recording the answers, and distributing them in media after the commencement of trial? In our next report, Real Talk will examine the actual video of the confessional statement that has been distributed to the news media. We will make an attempt to figure out how the video was made. Was this video a voluntary statement of a remorseful, dying man, or is it a forced statement collected under duress?